Supreme Court gave the Trump administration the green light to move ahead with plans to carry out mass layoffs at the Department of Education. They had been blocked by a federal judge. The conservative majority court offered no explanation. Justice Sonia Sotomayor wrote a blistering dissenting opinion. Joining me on the morning show, Fernandes, a constitutional law expert with the Constitutional Accountability Center. Good morning, Praveen.
Good morning.
So Justice Sotomayor wrote, the court's majority is, quote, either willfully blind to the implications of its ruling or naive, but either way, the threat to our Constitution's separation of powers is grave. And she said, the decision also rewards clear defiance of the Constitution. Praveen, does it, as Justice Sotomayor says, reward clear defiance of the Constitution?
Unfortunately, it does. It's incredibly unfortunate. It's important to be clear about what the decision does and doesn't do. This was an order that was part of the Supreme Court's emergency docket, sometimes known as the shadow docket. And so it's not a decision on the actual merits of whether this conduct was lawful or not. Instead, on Monday, in this brief unsigned order, the Supreme Court granted a stay, which is like a pause, to an injunction that a federal district court judge in Massachusetts had issued earlier this year. And what that federal district judge had done was looked at the entire record and concluded that what the administration had done in this drastic reduction in force that was essentially a reordering of an agency that was created by statute by Congress was unlawful. And so had ordered that these employees be reinstated. This order does not conclude from the Supreme Court, it's not a conclusion that the conduct by the Trump administration was lawful, but rather it's a temporary permitting of the firings to continue. And so while this litigation continues, in very real terms, though, there are some real harms, not only for the thousands of employees who are going to be fired, but also for the countless American school children across the country who depend on them.
But Education Department Secretary Linda McMahon praised the ruling as a significant win for students and families, calling it a real win for the future of American education, a win for education, or a major victory for the president at the expense of our children's education and civil rights in the Constitution.
Yeah, it's baffling, that quote. It's hard for me to understand how this could possibly be a win for the Constitution, for Congress that created this agency by statute, or for the countless American school children who are going to grapple with the effects of these firings. I think tragically we're seeing the effects of reckless and irresponsible reductions in force across the federal government in other areas. I think one need only ask the tragic victims of flooding in Texas whether they feel well served by a FEMA that has roughly 2,000 less employees than it did when Trump first took office. If you look at the Department of Education, now that the Supreme Court has granted this sort of green light, temporary green light to go ahead with the firings, this is a Department of Education that will have a workforce that is roughly half the size it was when Trump took office. That is a drastic and a catastrophic change in the resources allocated to this agency, in the human power that agency has to do good for the American people.
Skye Perryman, President and CEO of Democracy Forward, said, the justices dealt a devastating blow to the promise of public education for all children, which is what I think you're agreeing to here. And she said, while this is disappointing, the Trump-Vance administration's actions to decimate a department established by Congress are still unconstitutional. And while the justices' ruling allows Trump to move forward with his plans to decimate and dismantle the department, the High Court did not decide whether the administration's actions were lawful. That said, shouldn't the justices explain their decision?
Yeah, I think your great question is underscoring a problem that critics have long levied against the Supreme Court's emergency docket. The truth is we don't have an explanation of the justices' reasoning. There wasn't full briefing at the court. There was no oral argument by both sides. So what you see is there's a real lack of rigor in the decision-making process, and then there's also a lack of transparency. So these are two things that we ordinarily would associate with decisions that come through the Supreme Court's merits docket, but that's not what the American public gets with the emergency docket. The things that higher courts consider when they're trying to figure out whether to stay emergency injunctive relief that the lower courts had applied, things like the likelihood of success on the merits, the balance of equities on both sides, the public interest. We actually don't have any idea how the Supreme Court grappled or analyzed with any of these factors. Instead, the only thing we have is a 19-page dissent that Justice Sotomayor wrote and was joined by Justices Kagan and Jackson. So we have a sense of why it is that those three justices disagreed with the analysis, but we don't actually have any sense of the underlying analysis. In fact, we don't even know who authored the opinion or whether all six non-dissenting justices were part of that order. We simply know that there were at least 5 justices who agreed to allow these firings to temporarily continue. That's all the American public's left with.
And Praveen, is the fundamental ruling, or the fundamental question on this ruling, and maybe some others from the Roberts Court, does this undermine the basic rule of separation of powers put forth in the Constitution?
Yeah, I think you've put the question really well, and that runs through a whole variety of decisions. A lot of these decisions have, in essence, been arguments about the executive branch and Congress and what responsibilities, roles, and powers they have. And it's pretty clear that from the Constitution that only Congress has the ability to, through legislation, create new agencies, to create or to reduce those agencies. Congress has that sole authority to create, restructure, or abolish federal departments and agencies. And when Congress wants to give the power to make changes to the agencies, Congress has to do that through a statute.
Do you find it baffling that a man like Justice Roberts, who is mindful of his legacy, is allowing the court to proceed like this?
What I'm hoping is that we see a very different court when the merits actually get up to the court, because as you say, this is not just Justice Roberts' legacy, and of course this is the Roberts Court, but this is the Supreme Court's legacy in how it serves as a bulwark against unlawful conduct by an executive branch.
Yeah, and I think people question what's going on right now with the administration, with the court. Is it law that rules, or is it politics that rules? Praveen Fernandes, thank you for your time. Appreciate you.